At 2:17 this afternoon, Representative Marcus Vey asked National Security Director Alina Cross a question that had been prepared for 3 days. The question was 11 words long. Director Cross, did you personally authorize surveillance of Legislative Assembly members? The chamber went silent. Cross sat at the witness table, flanked by 2 legal advisors. She looked at Vey. She did not speak. For 17 seconds, she said nothing. And when she finally opened her mouth, the words were not an answer. They were a refusal that would trigger the most serious confrontation between the Legislative Assembly and the National Security Directorate in the Republic's history. Cross leaned toward the microphone. Representative Vey, I cannot answer that question in open session. The matter involves classified operational details under executive privilege. I am prepared to provide classified briefing to authorized members, but I will not discuss surveillance protocols in public testimony. Vey did not accept that. Director Cross, this committee has constitutional authority to conduct oversight of all executive operations. Executive privilege does not extend to potential illegal surveillance of elected officials. Did you authorize surveillance of Assembly members? Cross did not move. I have stated my position. I will not answer in this setting. At 2:19 p.m., Committee Chairman Stephen Lior intervened. Director Cross, the Legislative Oversight Act grants this body power to compel testimony on any matter related to executive conduct. Executive privilege is not absolute. If you refuse to answer, you are in contempt. Did you authorize surveillance of Legislative Assembly members? Cross did not hesitate. Mr. Chairman, I respect this committee's authority, but I have a duty to protect classified information. The question requires me to disclose operational methods protected under national security statutes. I am invoking executive privilege. At 2:23 p.m., Representative Dana Halvin made a motion. Mr. Chairman, I move that Director Cross be found in contempt and that we refer this to the Enforcement Bureau for prosecution. The motion was seconded immediately. Lior looked at Cross. Director, do you understand that contempt could mean criminal charges? Cross nodded. I understand. My position does not change. At 2:26 p.m., the committee voted 12 in favor, 4 against. Director Alina Cross was formally found in contempt. The question became operational. What happens when the head of national security refuses to comply with legislative contempt? But here is where it shifts. At 2:34 p.m., the executive authority issued a statement. The Assembly's contempt action is legislative overreach. The National Security Directorate operates under executive authority. The Assembly cannot compel testimony on classified operational matters. Director Cross acted appropriately. The executive will not permit criminalization of officials protecting national security. Any Enforcement Bureau prosecution will be blocked. That statement rejected the committee's authority to enforce the vote. If the executive orders the Bureau not to prosecute, can the Assembly compel enforcement? At 2:47 p.m., Chairman Lior held a press conference. The Oversight Committee has constitutional authority that includes power to compel testimony and hold witnesses in contempt. Director Cross refused to answer. We voted contempt. The executive cannot nullify that. We expect the Enforcement Bureau to prosecute. At 3:02 p.m., Enforcement Bureau Director Thomas Rahn issued an internal memo obtained by legislative staff. All personnel are advised the Oversight Committee has referred a contempt case involving Director Cross. The Bureau is reviewing the referral. However, the executive has indicated prosecution would interfere with operations. No enforcement action will be taken until legal counsel determines the appropriate course. The Bureau was caught between legislative authority and executive pressure at 3:18 p.m. Director Cross left the Legislative Assembly building. She walked out flanked by NSD security. Cameras captured it. She was not arrested. She was not detained. She walked out freely despite contempt less than an hour earlier. At 3:34 p.m., Representative Vey issued a statement. Director Cross was found in contempt. She walked out without consequence. If the Bureau will not act, the Assembly must consider alternative enforcement. We cannot allow executive officials to defy oversight with impunity. At 3:51 p.m., Assembly Legal Counsel outlined 3 enforcement options. Option 1, file a lawsuit seeking an order compelling Bureau prosecution. Option 2, invoke the Assembly's inherent contempt power and order the sergeant at arms to detain Cross. Option 3, withhold NSD funding until compliance. Each option had constitutional risks. Now watch what happens next. At 4:07 p.m., Chairman Lear convened emergency session of the full Assembly, all 240 members present. We are facing constitutional crisis. The executive claims oversight does not apply to intelligence operations. That would render this body powerless. I am proposing a resolution authorizing the sergeant at arms to enforce the contempt order. That was extraordinary. The sergeant at arms had not enforced contempt in over a century. If the resolution passed, Sergeant at arms would be ordered to arrest Director Cross and hold her in Assembly detention until she testified. At 4:23 p.m., debate began. Representative Julia Mendez argued against. This is unprecedented escalation. The sergeant at arms is not law enforcement. Ordering arrest of the National Security Director would create confrontation between legislative and executive security personnel. Representative Halvin responded, if the Bureau will not enforce contempt, the Assembly must. That is our constitutional duty. At 4:47 p.m., the vote was called 127 in favor, 113 against. The resolution passed. Sergeant at arms Colonel Victor Naresh was ordered to enforce contempt and detain Director Cross. At 5:02 p.m., Colonel Naresh issued a statement. I have received the resolution. I am consulting legal counsel to determine appropriate procedure. I will provide update within 24 hours. He was uncertain whether he could execute the order. At 5:18 p.m., the National Security Directorate issued a directive. Director Cross is under NSD security protection. Any attempt by external parties to detain the director will be treated as security threat. Personnel authorized to take necessary protective measures. NSD security would physically block the sergeant at arms. If he tried to execute the order, NSD would resist. At 5:34 p.m., the executive addressed the nation. The Assembly has voted to authorize arrest of the National Security Director for refusing to disclose classified information. This is unconstitutional. The executive branch will not allow it. Director Cross is performing her duties lawfully. Any detention attempt will be blocked. At 5:51 p.m., Chairman Lear responded, the executive claims no one can enforce legislative contempt. That destroys separation of powers. We will not withdraw the resolution. We expect Colonel Naresh to execute the order. There is a detail most people missed. At 6:07 p.m., Federal Court Chief Justice Mara Tolan issued a procedural notice filed electronically. The federal court has received informal inquiries regarding jurisdiction over disputes between the Assembly and executive concerning contempt enforcement. Such disputes are justiciable. However, the court will not issue advisory opinions. A formal case must be filed. The court was signaling if either party wanted judicial resolution, they could file, but the court would not intervene on its own. At 6:23 p.m., Assembly Legal Counsel filed emergency petition in federal court requesting an order compelling the Enforcement Bureau to prosecute. The petition argued the Bureau's refusal violated statutory duty to enforce legislative contempt at 6:41 p.m. Executive legal team filed counter petition requesting declaratory judgment that the contempt order was unconstitutional and the sergeant at arms lacked authority to enforce it. At 7:02 p.m., Chief Justice Tolan assigned both petitions to expedited hearings scheduled for 10 a.m. the following morning. The court would issue ruling within 48 hours. At 7:18 p.m., Colonel Naresh issued statement, in light of pending federal court proceedings, I am suspending execution of the detention order until the court issues guidance. The sergeant at arms was declining to act. He was waiting for the court. Director Cross would not be detained immediately. At 7:34 p.m., Director Cross appeared on national broadcast. I did not refuse to testify out of disrespect. I refused because the question would require disclosing methods and sources that protect this republic. I offered classified testimony. The Assembly rejected it. I will comply with any lawful court order, but I will not bow to legislative overreach. At 7:51 p.m., Representative Vey responded, Director Cross claims she is protecting national security, but from whom? From elected representatives. The question was whether she spied on us. If she did, that is not security, that is tyranny. Her refusal to answer is itself an answer. At 8:07 p.m., international observers issued statements. The Alliance of Democratic Republics released a message. We are monitoring the institutional dispute with concern. We urge all parties to resolve this through constitutional processes. The statement did not take sides. At 8:23 p.m., Enforcement Bureau Director Ron held closed meeting. Sources report he stated, we are in impossible position. If we prosecute Cross, the executive will block us. If we do not, the Assembly will hold us in contempt. We are waiting for the court. At 8:47 p.m., the Assembly convened, second emergency session. Chairman Leor proposed aggressive resolution. The Assembly declares that any NSD interference with the sergeant at arms constitutes obstruction and shall be met with funding sanctions. The NSD budget is suspended pending Director Cross's compliance. At 9:02 p.m., the vote was called 119 in favor, 121 against. The resolution failed. Enough members feared defunding NSD during operations was too dangerous. The Assembly's most aggressive tool was off the table. At 9:18 p.m., the executive issued statement. The Assembly's attempt to defund the NSD was reckless political stunt. Responsible members rejected it. This confirms the Assembly is interested in political theater, not legitimate oversight. At 9:34 p.m., Chairman Leor held press conference. The federal court will hear arguments tomorrow. We will make our case. If the court rules in our favor, we expect full compliance. If against us, we will reassess. But we will not stop conducting oversight. This is the moment it stopped being routine at 10:07 p.m. Assembly Legal Counsel received communication from federal court. The court requested supplemental briefs addressing, does the Legislative Assembly have inherent authority to enforce its own contempt orders, or must it rely on executive branch enforcement mechanisms? That question went to the heart of the dispute at 10:23 p.m. Legal teams began preparing briefs. Deadline was 8 a.m. Hearing at 10 a.m. Ruling could come the following evening. At 10:47 p.m., Colonel Naresh issued private communication to Assembly leadership obtained by media. If the court rules I have authority to enforce detention, I will require assurances that NSD security will not resist. I do not have personnel or resources for forced entry against NSD. If resistance is expected, I cannot execute without risking violence. Even if the court, said the sergeant, at arms could arrest Cross, he could not do it if NSD blocked him. Legal authority was one question. Practical capacity was another. At 11:02 p.m., NSD issued statement. The NSD will comply with any lawful court order. However, we maintain the Assembly's contempt order is not lawful. We are awaiting the court's ruling until then. Director Cross remains under NSD protection. At 11:23 p.m., Representative Halvin proposed a measure. If the court rules in our favor and the sergeant at arms cannot execute due to NSD resistance, I propose we request assistance from federal defense forces. The military has duty to uphold constitutional authority. Using the military to enforce legislative authority against an executive official had never been done. At 11:41 p.m., Defense Forces Commander General Alec Torin issued statement. The Defense Forces will not intervene in disputes between Assembly and Executive unless ordered by a court. We urge all parties to resolve this peacefully. At 11:57 p.m., Chairman Leor issued final statement before hearing. Tomorrow, the court will decide whether the Assembly can conduct meaningful oversight. If we cannot compel testimony, if we cannot enforce contempt, then separation of powers is dead. At 12:14 a.m., Director Cross remained at NSD headquarters. The sergeant at arms remained at the Assembly. The federal court prepared for hearing. No one knew how the court would rule or what would happen if the ruling was unenforceable. Here are the three scenarios. Scenario 1, the court rules for the Assembly and Cross complies. The court finds the Assembly has authority to compel testimony and enforce contempt. Cross is ordered to answer in classified session. She complies, legislative oversight is affirmed. Scenario 2, The court rules for the Assembly, but Cross refuses. The court affirms Assembly authority. The sergeant at arms is ordered to enforce detention. NSD security blocks the attempt. The Assembly considers requesting military assistance. The constitutional system fractures. Scenario 3. The court rules for the executive and oversight is weakened. The court finds executive privilege applies to intelligence operations, and the Assembly cannot compel testimony on classified matters. The contempt order is vacated. Executive branch intelligence operations become effectively unreviewable. The hearing record shows that at 1:47 a.m. on the morning before the federal court hearing, Director Cross remained at National Security Directorate headquarters. Under NSD protection, the Assembly sergeant at arms had suspended execution of the detention order pending judicial guidance, and the federal court had not issued any preliminary ruling. The procedural log contains no entry resolving whether legislative contempt can be enforced against executive branch officials who invoke privilege. What happens when oversight cannot compel compliance is not answered by the authority claiming oversight. It is answered by whether the institutions meant to enforce that authority choose to act.